Hey everybody, how's it going? My name is Will and welcome to Copper Jacket TV. So we actually have some exciting breaking news today. Even though the Supreme Court is not officially back in session until next Monday, October 6th, we got an order list this morning. And through that list, we found out that the Supreme Court has decided to accept a Second Amendment case out of the Ninth Circuit Court of Appeals. But before we get too excited, I have to mention that they only accepted it in part. So today, let's talk about the new 2A case that was just granted cert by SCOTUS. Now, real quick before we get started, one of the best ways you can support channels like this is simply by hitting that subscribe button or scanning that QR code. It's free, it only takes a second, but it really does help us out here quite a bit. And I want to apologize for my voice yet again. It's been like this for about a month. Got a doctor's appointment later today, and hopefully we can figure out, what's going on. So with that being said, let's go ahead and get to it. Okay, so let's go ahead and talk about what's going on here. So, as I'm sure you know, the Supreme Court does not grant cert to very many Second Amendment cases, but when they do, the outcome can be huge. I mean, consider Bruen. Bruen was just a carry case out of the state of New York, but that case ended up changing the Second Amendment landscape in this country forever. As a matter of fact, it was more than likely Bruen that got this case accepted in the first place. Now, the case that we're talking about today is another carry case, but this one originates from the state of Hawaii. If you know anything about Hawaii, you know that they have some of the strictest gun laws and carry laws in the entire country. The case is called Wolford v. Lopez, which was actually heard at the Ninth Circuit Court of Appeals, along with another very important carry case called May v. Bonta. Now, like I said in the beginning, the Supreme Court only granted cert to part of this case, which isn't great, but at least the question that will be answered is an extremely important one. As a matter of fact, it's question number 1. That's what they'll be deciding. So let's go ahead and take a look at the case itself. That'll give you a better idea of exactly what we're fighting for here. Okay, so here's a look at Wolford v. Lopez. Again, the case that was just accepted by the Supreme Court this morning. Now, like I said, they only accepted this case in part, and that part was question 1. They've decided to accept cert for question 1 and essentially let question 2 go. So let's go ahead and take a look at what question 1 is. Question 1 says, whether the Ninth Circuit erred in holding in direct conflict with the Second Circuit that Hawaii may presumptively prohibit the carrying of handguns by licensed concealed carry permit holders on private property open to the public unless the property owner affirmatively gives express permission to the handgun carrier. And again, question number 2 is out. Now, some of you might recognize that language as what's been quoted as the vampire rule. Essentially, this case is challenging a restriction that says unless a private business owner puts up a sign or something that expressly permits carrying on property, you can't enter that property even if you have a permit. So you can see that a law like that could make carry virtually impossible. There would be no way to carry without at some point being disarmed. It could make nearly an entire state a gun-free zone. California tried it, New York, Hawaii's got it. I can almost guarantee that there's going to be other blue states that are considering this as well, or at least something similar to it. Imagine looking for a "you can carry here" sign at every single place you went. It's impossible. Now, even though question number 1 should be very easy for the Supreme Court to answer, it's clearly unconstitutional, there's still something else to consider here. And that's depending on the language of the decision in Wolford, regardless of which direction it goes, this could have a huge effect on the whole sensitive location argument happening in states all over the country right now. Remember, Bruen was a carry case, and that changed how courts decided 2A cases across the country. So this is one that we're going to watch very closely. Hopefully it's just the first of many cases that the Supreme Court will take this year, but I'm not going to hold my breath. I mean, I really hope that this isn't the Supreme Court just throwing us scraps and saying, hey, look, we accepted a Second Amendment case in 2025, and then they let everything else go. Like we see Duncan and Gators and other cases that have already made it to the Supreme Court and other cases that are about to make it to the Supreme Court. As a matter of fact, there was another petition just filed today challenging another, so-called quote-unquote assault weapons ban. So there's a lot up at the Supreme Court right now, and the Supreme Court has a lot to answer. So I'm hoping that this isn't just one of those little things where they just throw us peanuts and then forget about the rest. This is something that they need to answer, yes, but don't forget about the other cases that need to be answered as well. So I wanted to let you guys know about that, let you know what's going on. I want to thank you all very much for watching. I really do appreciate it. If you haven't done so already, consider hitting that subscribe button. The thumbs up's always appreciated, and that little alarm bell will let you know when new videos come out. And wish me luck at the doctor. Hopefully I can get this voice thing fixed. It's getting a little bit ridiculous now. Thanks again. Y'all have a good one.